Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please.
Good morning.
Good morning.
Case number 25-7112, Marion Coster and Coster Realty LLC appellants versus Stephen S. Schwat et al. Mr. Ross for the appellants, Ms. Baum for the appellees.
Good morning, Your Honors. The district court's grant of summary judgment was error both procedurally and substantively. Procedurally, the district court erred in granting summary judgment on a ground not raised in defendant's summary judgment motion or its supporting memorandum, namely that the actions that we allege constituted breaches of fiduciary duties were protected by the business judgment rule in Delaware. Defendants did not make that argument in their summary judgment motion. Instead, they argued that there's no evidence at all in the record that the defendants committed the acts that we allege constituted fiduciary breaches, and that the collateral estoppel doctrine barred one of our claims. In fact, nowhere in their summary judgment motion or in their 23-page opposition or supporting memorandum did they even mention the business judgment rule or the entire fairness standard. There's no mention of that whatsoever. As the Seventh Circuit held in Malhotra, a case that we cite in our reply brief, when a party moves for summary judgment on ground A, the opposing party is not required to argue ground B when that ground could have been raised by the moving party, but they chose not to. And that's exactly what we have here, Your Honors. Defendants who are represented by highly skilled counsel decided for whatever reason not to move for summary judgment on the ground that if we committed the acts that Coster alleges we did, they're protected by the business judgment rule.
So instead, I take some of that, but I read their motion, their summary judgment motion, a little broader than just saying we did not, intentionally suppress profits. They do say, to your point, they do say we did not intentionally suppress profits, but I think they also say, and even if we did, it was legal and fair.
Right. And
they've got some quotes here. I'm curious why you think they don't basically say what I'm saying they say. Your experts do not identify a single transaction whereby money was improperly or unlawfully transferred to any SPE. So they're not saying no money was transferred. They're just saying the transfers were not improper or unlawful. They say, quote, servicing the related entities is what UIP was established to do. So they're saying it could be read to be saying it wasn't established to make a profit. It was established to service the related entities. And then last quote here, any assertion that such transactions represent evidence of fraud or malfeasance ignores the basic structure of UIP as contemplated from its inception.
Yeah, so that goes to what standard applies. Under the entire fairness standard, if that applies, it's their burden to show that everything was entirely fair. They didn't put forward evidence doing that. And the district court erroneously held that it was our burden to show under the business judgment rule that A, it didn't apply, and B, it wasn't satisfied here. So that's why the
business judgment rule, the default, and then if you want, that's how defaults work. If you don't want the default to be applied, the burden is on you to rebut that it's the default, to rebut that the default is the appropriate standard.
That would have been true if they had moved for summary judgment on the ground that their acts did not violate the business judgment rule.
Well, I guess that's what I'm saying is, I think they sort of did. Those three quotes are sort of saying like these acts that you allege were not improper. They didn't violate the rules.
Well, nowhere do they mention the business judgment rule in their supporting memorandum.
But that's the entire. So you don't often. It's often the case you don't mention the defaults. It's the exception to the default that you would be expected to mention if you don't want the default to apply.
Well, they didn't argue. They argued that there's no evidence that these acts happened.
They did, but then I thought they made it in the alternative argument that even if these acts did happen, A, B, C, not improper. This is what UIP was supposed to do. No evidence of fraud or malfeasance.
Well, we certainly weren't on notice that they were contending. They were certainly aware of the issue of the entire fairness rule versus the business judgment standard, because in Coster 1 in the Court of Chancery, before then Vice Chancellor McCormick got to the analysis, she spent a lot of effort in her opinion discussing whether the entire fairness standard applied to our claim there or whether the business judgment rule applied. And she determined that the entire fairness standard applied. So we were not on notice when we prepared our lengthy opposition brief that they were contending that what we alleged, that they were on both sides of these numerous transactions, that they took the position that the entire fairness standard did not apply. Had they taken that position, we would have had the obligation under Rule 56C to put forward evidence, A, that Schwat and Bunnell were corporate fiduciaries. In other words, they're either controlling stockholders or board members, and B, that they stood on both sides of the transactions that we challenged. If we established both of those facts, then the entire fairness standard would apply. But they didn't do that. They just said, oh, this stuff didn't happen, or, their experts can't prove that any specific transaction.
Were you on notice from their motion?
We were not. So,
Wait, finish my sentence?
sorry. Apologies.
Maybe it'll still be the same answer, but were you on notice that when they made the statements Judge Walker referenced, that they were saying, that they were arguing that even if we intentionally ran this not to have a profit, that decision fell within the business judgment rule? Did those three sentences he mentioned put you on notice that they were doing that alternative argument? Or do they simply, or did you understand them to be simply statements about, and therefore it wasn't improper, it wasn't unlawful?
The latter, Your Honor. We specifically note in our opposition brief at footnote 7 that they hadn't raised the issue of which standard applied. And if they had, the entire fairness standard applies because we alleged that they were on both sides of the transactions.
What happens if a summary judgment, the movement makes arguments that at least 98% of which clearly are simply pushing one theory here? We didn't intentionally run this to not make a profit. And then there are some ambiguous lines that could be read as consistent with that or alternative arguments. Who has the burden of putting the court and the other side on notice?
The move-in does. The move-in does, Your Honor, under Silotex, the Supreme Court opinion interpreting Rule 56. It's incumbent upon the moving party under Rule 56 to identify each of the grounds on which it's moving.
Silotex in your appellate opening brief to our court?
I don't believe so, but we certainly cited it in our reply because they invoked 56 and support.
Forfeit arguments that are raised for the first time in a reply.
We did make the argument that the district court erred in granting summary judgment on a ground and on an issue not raised in their summary judgment motion and supporting memorandum. We clearly made that argument on our opening brief, Your Honor, but I will acknowledge that we did not cite Silotex.
Can you forfeit controlling case law? I think the Supreme Court said otherwise.
I actually don't know the answer to that, Your Honor.
Sorry.
It's a little bit of an odd position to imagine a summary judgment question divorced from any inquiry about the underlying legal rule.
Well,
I mean, the summary judgment depends on whether there are disputed issues of material fact, and the substantive law determines what's material. So, I mean, it seems odd to have a kind of law-free summary judgment motion in the way that you're attributing to your friends on the other side.
I think the district court would have been entirely it would have been entirely reasonable for the district court to rule there's a genuine issue of material fact as to which standard applies, and either request supplemental briefing under Rule 56F on that issue or deny summary judgment with leave to file another one. But we certainly they were taking the position as we understood their brief, and I think it's any fair reading of the brief, that, hey, we didn't commit these acts. So it didn't matter which standard applied because if we didn't do these things, we have no liability regardless of what standard applies. That was certainly the thrust of their brief. They did not rely on or cite the eBay case that the district court relied upon for the proposition that it's perfectly okay under Delaware law not to run a corp, an Inc., for profit. They did not raise that issue in their opening memorandum or in their summary judgment.
You now seek to challenge some more specific actions like the interest-free loans and things of that nature. You think did they deny the existence of the loan?
They deny that there was any material loan made that affected our client in any adverse way. And they couldn't deny the so-called consulting fee payments. So that's why they moved.
Right. But that's my point, that there are specific acts at issue and you're contesting the legal consequence of those. I don't know how you do that, how one can do that without a debate about, are we assessing these acts under the business judgment standard or the complete fairness standard?
Well, with respect to the consulting fees, they knew they couldn't deny those.
Mm-hmm.
They clearly stood on both sides of those transactions. So with respect to that one claim, that one issue, they said, oh, collateral estoppel applies because of the holding in Delaware. So that's why they made the collateral estoppel argument, because they couldn't deny that. Everything else, they said, oh, there's no evidence. Koster had to call it discovery and all these experts, but there's no evidence that we actually did these things.
I thought this is, I think Judge Katz's first question, but I wasn't sure what your answer was. A loan was made and they did not deny that a loan was made. Is that correct?
They denied that there was anything improper about it. That's correct.
So, but they did not deny that the loans were made.
Right. But they had other justifications for why it didn't cause any damages to my client, such that it would be a breach of fiduciary duty.
I just had a question quickly about, just to make sure I understand the scope of the summary judgment issues for us. So you have counts in your complaint for aiding and abetting and civil conspiracy and declaratory and injunctive relief, but you haven't challenged the district court's dismissal of those claims. We haven't argued about aiding and abetting or civil conspiracy or declaratory and injunctive relief as opposed to monetary relief going either to the corporation or to you, your client.
The focus of our appeal is the breach of fiduciary duty claims. That's correct, Your Honor.
Okay. And then you have a number of other counts that seem to raise direct rather than derivative claims, but I haven't taken but tell me if I'm wrong, I have not read your brief before us as to be challenging the summary judgment as to those direct claims that you're here on the breach of fiduciary duties and derivative claims. Is that right? As a derivative claim?
We believe it's both a direct and a derivative claim.
Have you argued before us? My understanding of the brief before us was all about derivative claims on behalf of the corporation. And
we did not intend for it to read that way. We believe that my client, Mrs. Koster, has direct claims against Mr. Bonnell and Mr. Schwat for breaching fiduciary duties they owe her in their capacity as controlling stockholders and as board members. So we don't read those as derivative claims.
well, because I read the other side's brief to us to be arguing that you only have derivative claims. You can't have direct claims against them. And I didn't see you countering that argument in your red brief other than to say, give us a pro rata share, which really is a framework for analysis and derivative claims.
Right. We didn't address that issue because the district court didn't reach it.
Well, granted summary judgment on all claims. You don't still have is it your view that the district court did not rule on the direct claims?
Not at all, Your Honor. So let me clarify. So the issue that we briefed in our red brief is whether, to the extent there are
Your blue brief, I apologize, your blue brief.
the blue, yes, in the blue brief, to the extent there are derivative claims on which damages are ultimately awarded, whether they can go directly to her, which we argue under Delaware case law, absolutely they can under these facts,
Yeah, I understand that.
versus to the corporation.
But you didn't challenge, I guess I didn't see you challenging dismissal of your direct claims. The other counter said they aren't viable. You only have derivative claims.
Well, we thought we were appealing the entire summary judgment order.
Okay, all righty.
So unless the panel has,
Suppose we get over the forfeiture argument that you're pressing, just on the merits. How do we know that Schwat was a controlling shareholder? I mean, it's 50-50. The premise of one of your Delaware actions was that the corporation is hopelessly deadlocked, which implies absence of control by either shareholder.
under the Khan case that we cite, a Delaware Supreme Court case. So for the first 3 years and 4 months after Mr. Koster passed away, until the stock sale on August 15th, 2018, Mr. Schwat was a 50% stockholder and my client was a 50% stockholder.
Right.
However, he was chairman of the board. My client did not have a board seat. He was also CEO of the company. All the testimony, which we would have put in the record had this issue been engaged in the summary judgment motion by the defendants, he ruled UIP with an iron fist, and Bunnell basically did what he was told by Schwat. So, if we had been allowed to put in evidence,
So
it's overwhelming that he was in fact a controlling stockholder.
One gets that sense from just looking at this. I didn't see a lot of evidence beyond that. And maybe that just comes back to the question of whose burden it is.
Right. Had they engaged on that issue by moving for summary judgment on the issue of which standard applied, absolutely, we would have put all of that extensive record of evidence into the record in opposing the summary judgment motion. Absolutely, we would.
And I assume you would give me roughly the same kind of answer vis-a-vis the board, which at least formally Schwat has only 1 vote out of 3, and we don't know a whole lot about Bunnell and Cox.
So the evidence, unfortunately, Mr. Cox is no longer with us. The evidence, and it's abundant in both in discovery in this case and discovery elsewhere, including Delaware and some ancillary cases, that Mr. Cox was very subordinate to Schwat and Bunnell, did whatever he was told, was CFO in name only. In practice, he just took instruction. He never once disagreed with anything they suggested. So the evidence is powerful there as well. That Schwat and Bunnell, following the stock sale in August 2018.
Is all of that in the summary judgment record?
It's not, because we didn't think we needed to put it in.
We're circling back to the question whose burden it was.
Right, and that highlights from our perspective the unfairness of not being on notice that this was going to be an issue on which the district court would rule.
I got it. Thanks.
Okay, thank you.
Thank you very much, counsel.
Thank you. May it please the court, Deborah Baum on behalf of the defendants. Mrs. Koster was the plaintiff below. She had the burden of proof. We moved for summary judgment on the principal basis, as the court has noted, that there was simply no evidence to support any of her theories. The default standard in fiduciary duty claims under Delaware law, the baseline, as the Delaware Supreme Court has repeatedly said, is the business judgment rule. We moved under Rule 56C for summary judgment, saying there's really no evidence of any of this violation of breach of fiduciary duty. Yes, certain interest-free loans were made. They've been doing that for years between companies that basically were co-owned. And yes, they paid bonuses, consulting fees to the owners the same way they had for years, but there's no evidence of what The plaintiff had claimed to the court in seeking wide-ranging discovery of these siphoning money out of the company to the harm of its now one-third shareholder, Mrs. Coster. We said simply didn't happen. Did we say, and by the way, Your Honor should apply the business judgment rule, which is the default standard in our moving papers? We did not, but it's the default standard. They had the burden.
Go ahead.
Excuse me, sorry.
I mean, it might be the default standard, but we didn't do any of the facts alleged is a different argument from if we did, it's fine under the business judgment rule.
Well, I think we argued both, really. I said the primary argument was there's no evidence of any of this. And we did say there's no evidence that any of this violates Delaware law. And there's the whole collateral estoppel issue because the Delaware Supreme
What
Court.
is the this? That when you say this didn't violate, because it wasn't at all clear to me that you were arguing that even if we intentionally suppress profits in a way to prevent her from Ms. Foster from getting dividends or payments, that's okay under the business judgment. Where is that? Can you tell me the pages in your summary judgment brief where you argue that to the district?
And Your Honor, I don't think we argued it that way.
Okay.
To be clear.
Right. No,
But
I understood your,
but-
oh, please. Go ahead.
the plaintiff has the burden under Celotex, under Rule 56, to come forward and say, here's all the evidence as to why there is evidence of a breach of fiduciary duty. We said no evidence of a breach of fiduciary duty. She had the burden to come forward and say, here's evidence of a breach of fiduciary duty, and here's evidence of why you should apply the entire fairness standard.
I understand, but
And-
then we get into the problem here because the district court didn't say there's no dispute of material fact as to whether there was a breach of fiduciary duty. What the district court said was, I'm assuming, even if I assume you intentionally suppressed the profits, that was okay under Delaware law, something you hadn't argued, and then said it was also okay because Ms. Foster had a chance to invest in the SPEs, something else that you were not arguing is a basis for summary judgment.
Well, part of,
Am I right that neither of those two grounds were argued by you for summary judgment?
I think we did argue that she had not been denied any value.
That's,
And-
no, that's a different thing from,
Well,
you didn't, what the district court did was, I'm assuming you intentionally suppressed profits and Delaware law allowed you to do that.
well,
If you had that intent to suppress profits, whereas your argument seemed to be, one, we didn't, there were all these profits. And two, you don't have any evidence that these transactions you don't like were designed to get you, as opposed to that was how we did things. As you just said, that's how we do things.
well, I think the court did find, Your Honor, that, and I quote, the plaintiff failed to prove that defendants ran UIP in a way that denied her value in her ownership of the company.
Plaintiffs don't have to prove something to summary judgment. They just have to raise a disputed question of material fact at summary judgment.
Well, I understood the court's order to be that they had not come forward with evidence, but then he did go on, the court did go.
But the court needs to find no dispute of material fact, right? You have to look at the factual record presented by both sides. I understand your argument to be that the district court could have ruled that way, but there seems to be quite a disconnect. I mean, you're arguing one thing.
Mhm.
They're arguing another thing. And the district court sort of said, well, I got door number 3. And so that's what's very confusing to me as the problem here.
Yes, well, I think part of the issue was just to can I give a little bit more context here? There's a very sort of far-reaching complaint. The Delaware Supreme Court en banc had ruled and said the underlying transactions that initially were the bedrock of their complaint, the Delaware Supreme Court said that didn't violate, that was not a breach of anyone's fiduciary duty. So those claims were out of it. It was not entirely clear what was left. And they went to the court and said, we think they're siphoning money out of the company and giving it to themselves, basically. We need discovery to be able to show you that money is going out to these individuals to the detriment of our client who's a third owner. And there were all kinds of things sort of in the background. It wasn't crystallized exactly what they were even arguing, but they went to the court and said, we want discovery of all the financials. They got bank records for the individuals, for the LLCs, the individual entities that were the owners. They got their bank records. They got ledgers of all of 12. They got to identify 12 different SPEs, different projects, got all the records of all of them, and then came back with expert reports that didn't identify any of the kinds of things they said they thought they could find. So yes.
Your argument was they didn't have evidence of this siphoning off
of
for
money.
self-benefit.
And they came back and said, yes, but you are running it. They came back and they're in response in order.
So you had this discovery and you guys look and go, there's nothing here
Nothing
about
here.
them siphoning money off into their own pockets. And so then you understandably file a motion for summary judgment saying there's no there as to
Correct.
siphoning off money into their pockets.
Correct.
And they come back with their opposition, but you chose to do summary judgment on that theory. Understandably, that's the course of discovery. But the district court doesn't say that. That's the problem. The district court does not grant summary judgment on the ground that there was no dispute of material fact, genuine dispute of material fact as to this siphoning, either for self-benefit or siphoning away from Mrs. Coster. The district court instead says, assuming there is, that's fine under Delaware law, which is just a very different argument. And then the separate argument that the district court relied on, and even if you're doing this, she was offered a chance to participate in this siphoning process. Yes, and she was offered the opportunity to invest in the SPEs, right? And so those are the two things the district court ruled on, which just, I mean, this is not a you problem. This is the question here is the district court wasn't responsive to the argument that you guys were making based on the discovery record.
I think your honor is correct in that the district court perhaps didn't use the words no issue of material fact in the finding, but the court said there's no evidence of this. No evidence, not just there's not a material issue, but there's no evidence of what they're claiming here. And the siphoning off, as we've referred to it, is something different, I think, than investment in these SPEs. It's a different thing. What they came to the court to say is we think money is being taken out of the company wrongfully.
Where is this no evidence statement? Which one are you applying or referring to?
Well, I think there are a number of them. In the court's opinion at page 11 of 17, I think I have a joint appendix cite to that, 2861. The court,
I unfortunately have like a Westlaw version, but
Oh,
which
I'm
heading
sorry.
under? Then that's my fault.
it's page 11 of the court's order. Now, I thought I had it here at the podium. I don't. But the court said their plaintiff failed to prove that defendants ran UIP in a way that denied her value in her ownership of the company. But then
Denying value is not the same thing as saying there's no issue of material fact as to, that's denying her value. I'm right.
Yeah,
That's a different question.
But I can keep going. Plaintiff fails to make the case in terms of the consulting fees. Plaintiff fails to make the case that these payments were improper and resulted in a breach. She offers no proof regarding the board's knowledge and consideration of the consulting agreements. And then plaintiff has come forward with no proof about the fees other than their payment. That's at page 15, Joint Appendix 2865.
I mean,
The one
all
I-
of this was, the district court did this all through the framework of saying running UIP, this is their heading, running UIP at break even is not a breach of fiduciary duty.
Right, and then in
Did you
the, under
argue
the,
that running, if you had run it at break even, do you ask for summary judgment on the ground that us taking their argument at face value, running it at break even is consistent with fiduciary duty?
well, certainly on our reply we did. They came back and said, but you ran it at break even and that's a violation of Delaware law. And we came back in our reply and said, essentially, no, it's not. We disagree. And to the extent that I heard,
Because it was within business judgment rule?
yeah, well, because the entire fairness standard didn't apply and they argued it.
Doctrine doesn't apply is not an argument that something is lawful
Right, well, we said both. We said it's lawful.
because
The Delaware courts have said it's lawful. And the business judgment rule is the default standard. And we said under eBay, and we had arguments about this in the hearing on summary judgment. You know, I heard a lot of and read a lot in their briefs about there not being an opportunity to argue these things. The court held an extensive hearing on the motion for summary judgment and asked specifically in the entire fairness rule, the applicability of the entire fairness rule was discussed at length. And this is at Joint Appendix 2892 and forward. Goes on for pages.
so you were relying for your law on In re Trados, right? But that was about Revlon duties at a sale. That
Yes,
That's another one
yes,
here.
Ron
And then
Perlman, yes.
eBay versus Newmark, which I actually think hurts.
Well, I think the plaintiff relied on eBay and said you can't run a company not for profit.
Right.
And what I think the court
What they
correctly.
said there.
Well, it said, it's a little bit nuanced, Your Honor. What it said was if you're a Delaware corporation, you can't just be philanthropic, period. And it said, we're not saying that you can't have corporate retreat, you can't have things for culture. There has to be a proper corporate purpose. And
But
what,
if you look at it through this lens, right, you can't forego profits just because you want to do this other thing over here. And as long as you can do these charitable things, as long as you are making value for your shareholders.
but
I mean, when all these SPEs make money, does that increase the value for UIP shareholders or just for SPE shareholders? Or
well,
others,
the
whatever.
concept, and this was brief.
No, I'm just asking a fact question. When money is made, when this decision is made to take money out of the corporation, put it into these SPEs, and let's say the SPE works out, let's say two of them work out really well and make a ton of money, who gets that money?
There's a, if I may, Your Honor, that's a slightly faulty premise.
Okay.
The money doesn't come out of the entity UIP into the SPEs. The way it works is, and this is all explained in the Delaware opinions, the concept was, and a lot of real estate companies are set up this way, the owners have their three subsidiaries, a contractor, a property manager, an asset manager. And the principals themselves invest their own money in these special purpose entities. They invest in a new project and they typically have a big equity partner, a big lender that owns the majority of it. But the way they create value, as Mrs. Coster's late husband said, and is quoted in many of these opinions as saying, the way we create value is in managing these properties, managing these investments of ours through our entities. In fact, the properties are the ones, those special purpose entities pay money to UIP for property management services, for asset management services, for construction.
So I understand the structure. I
Yeah.
want to get back to my straightforward question, okay?
Yep.
When an SPE makes money, does that, and let's assume maybe two of the shareholders are invested in that SPE. but not a third of UIP. Okay. So that SPE makes money. Does that increase the value of the shares of UIP itself, including for those who have not invested in the SPE?
Yes, it can in two ways, but in one way, if they don't
It
invest.
can.
Yes,
Not it can. Did it?
yes.
For,
And that's what the court found, and that is what was briefed and held by the Delaware Supreme Court as well, which was, it was created to create value for the shareholders in providing them an opportunity, providing shareholders these opportunities. They source.
That's separate.
That's
separate.
what they do,
That's
but,
separate. I'm just trying to understand.
but
If value over here also increases value here at UIP, because
in a second way too, because those entities, those properties are the vast majority. They do some third-party work as well, but the vast majority of the income that UIP gets through construction, through property management, they're doing property management services for these
that doesn't mean
SPEs.
you're increasing value if that money keeps going out into these other investments. So
It's not going out, it's coming in.
is it, but so are they running a break even, or does it mean they're making profits?
They made this much less profit. They made, I think they said in the last, 6 years that they had records of, or that their experts analyzed, they made about a 5.48% profit on average over that period. The industry average was 6%.
Mhm.
So they said,
I understand you definitely made that argument.
yeah,
through the
you
district
could have
court
made a little bit better,
that,
but
there was no, the profits were being made.
But-
That was a fact argument to the district court, and
But the money comes in from the SPEs, from those properties for whom they provide property management services. So it's essentially, we're going out and we're sourcing, one of the things that the principals
it
did.
just sounds like the genuine disputed material fact. You're saying, no, profits were coming in, your value was going up. Her argument is my value stayed flat. I was paid no money. No dividends or shares were distributed, nothing. That's just and I understand your explanation, but this sounds like a genuine dispute of material fact.
Well, the court found that there was no evidence that she did not benefit from the value that was created within the entity, and that there was no, under Delaware law, there was no requirement, no legal requirement that shareholder value
She
take
wasn't
the form.
deprived of value is not the same thing as she wasn't paid value, right? She's not saying losing money. She's saying, I'm just sitting here staying flat. District court found no deprivation of value. Right.
Right. The district court found that
But that's.
there was nothing being done to deprive, well, in a breach of fiduciary duty claim, I think you do have to claim that you were damaged, that you were deprived of value.
Right, but I think she
And-
did that through, look, you were taking all this money, spending it out there. All this money was being made by you guys. I'm
Well,
not saying any of this is, I'm not making anything about fact findings, true or false. I'm just trying to describe my understanding of the arguments.
Well-
Is all this money, tons of money was being made over here, and meanwhile, I'm sitting here flat. So that's just there's just a disconnect between, I think you had your arguments, understandable based on the discovery. She had hers, and then the district court just seemed to have a completely different take on it.
well, I think part of the district court's take was part of the value, or the principal value that was being created here, was the opportunity, sourcing opportunities to invest in these projects, real estate projects. That's why they
That's
were
only
founded.
value. That's only value if you have the resources to make those investments. That was her argument. I didn't have those resources.
I changed my mind. I don't want to do it anymore. And so.
Or I don't have the resources to do it, whatever it
or
is.
I don't. I mean, the
Right, so
record.
that's not value to
The
her.
record did show, just to be clear, that since her husband passed, she had been paid $2.8 million in distributions from these SPEs.
I
So-
assume pre-existing investments by her husband.
Yes, because she decided then, I don't want to do it anymore. So the question is, when you've created a company whose purpose is to source investments, to give opportunities to the principals to invest in these deals, and then the deals in turn create revenue for the company, do you have to change your model and not do that anymore? It's not that they
I
were.
just think that's the very question under eBay. If you have a corporation, and your argument is, well, we're going to adopt this business strategy over here that's going to not have value made in this, we'll call it the UIP, the spoke here, or
Yes.
it's the center, the hub, I guess. Instead, all the value is going to be created out here in these SPEs for those who have the money to invest in SPEs. Is that consistent with eBay versus Newmark?
Well, I think it is, Your Honor, because eBay says you have to maximize value. It doesn't say you have to get every last dime. It says in a unique situation in 2010, it's a 2010 decision, you can't run it as a nonprofit in perpetuity. You can't force that on the next generation.
Here.
But
Trados. These are just fact arguments about whether that's in fact what was going on.
But Trados, 3 years
It's a
later,
different test. That's the test for maximizing value in a sale, regardless of whether you like the way the new owner is going to run the company.
but the holding.
This isn't a Revlon situation.
But what it talked about was the duty, the question in both really was, what does the duty of loyalty mandate in terms of maximizing value? And what Trados said was the duty of loyalty mandates that directors maximize the value of the corporation over the long term for the benefit of the providers of equity capital. Value, of course, does not just mean cash. It could mean an ownership interest in an entity, a package of other securities, or some combination with or without cash that will deliver greater value.
All of which are given to the corporation's shareholders, not that they have to go invest for on their own. And yeah, I'm sorry, I've taken up a lot of time.
Right, but it's an opportunity, and then what the court found was there was no demonstration here, no facts here to show that she was deprived of anything.
I want to continue the same general line of questioning, but take a step back from the facts. Whether this was losing money, breaking even, making money, whatever. I take the district court to have adopted a legal theory that it does not violate Delaware law for one corporation to be run in order to maximize benefits for owners of a different corporation. This is not a question of defining value in some long-term sense or in some expansive sense to account for, feeling good about corporate philanthropy or anything like that. This is something entirely different. This is one entity can be run to benefit shareholders of a different entity, and that sounds remarkable to me.
Well, it's not you're run to benefit shareholders of a different entity. It's run to benefit your own shareholders by providing them opportunities through these other entities. To be clear,
I mean, it doesn't. If UIP is designed to make as much money as possible for the owners of the SPEs, like, that's great if all those companies have the same owners, but they don't right now.
And it has been, but they all have the opportunity. They all have the opportunity. To be clear, the Delaware Chancery Court, now Chancellor McCormick, and the Delaware Supreme Court en banc found that this was the way this company was run. And no one said, whoa, you can't do that. I mean, that they had a breach of fiduciary duty claim there related to the business of this very company. They made factual findings that this was the purpose for which it was created and how it had been run for years.
I
And
take
there
that
was no
point.
suggestion.
There does seem to be a general comfort in the Delaware Supreme Court in this arrangement, and we're sitting in diversity. I get that. I'm a little nervous about this, but this issue was not before them. I mean, they were just focused on the fairness of the price for the third guy to buy in, Bruggen, I think, to buy into the company.
Well, yes and no, Your Honor. Yes, insofar as the entire fairness talked about process for sure and value, but the way they got at value was, and the way the valuation is done in a situation like that, is to look at net cash flows. And that's why the issues of these bonuses or consulting fees came up. They said, oh, they're paying outsized bonuses, they're doing this. And they raised the entire issue. That was a big issue. And I tried the case, it was there. It was a huge issue, was they're trying to run at break even. They're not trying to make money. That was a big issue that went into the entire fairness calculus. So it was very much front and center in the court. And
So your best authority for Delaware courts blessing this model are the litigation, in this case to date, and Trados?
I think so.
Okay.
Yes, I think that's right, Your Honor.
Okay.
Because it was, to be clear, that issue was front and center. The testimony that they cite, a lot of that was from the Delaware litigation, because that question was front and center there in the entire fairness analysis.
Okay.
Unless the court has anything else, I thank you very much.
Thank you very much, Counselor. Mr. Ross, we'll give you 2 minutes, please. Everybody?
Thank you, Your Honor. I heard my friend Ms. Baum say that it was our burden on summary judgment to prove our claims, and that's fundamentally the error the district court made here. It was our burden on summary judgment to prove our claims, that the siphoning of money and all the other things. That's not true when we're the non-moving party. Our burden is exactly what Judge Millett identified, is to show that there's a genuine issue of material fact. And that's what we did in spades below. If you look at our opposition brief and the extensive record evidence cited in it and submitted as exhibits at the summary judgment stage. And if we were to go to trial, if we were permitted to go to trial, there would be abundant evidence that although my client has received some distributions, really almost all of them in the couple years after Mr. Koster passed, she hasn't received anything material, anything above 4 figures in the last 6 or 7 years. She's had to sell her house because she doesn't have any money. The record would show, if we went to trial, that Schwat and Bonnell are very wealthy. It's because of the money they've made through the SBEs and a function of paying themselves so-called consulting fees, even though millions of dollars in consulting fees, even though they're full-time, highly paid UIP executives. My client hasn't received any consulting fee, any dividend, any distribution, or anything of value as a result of her 1/3 ownership of UIP and 1/2 ownership prior to the stock sale in August of 2018. Thank you.
Oh, you were going to ask a question? Sorry.
Go ahead.
Oh, sure.
Sorry, Ms. Baum mentioned the hearing transcript. And I looked at the page, she mentioned 2894. And the district court said, well, only if it's an entire fairness review. Otherwise, it's your burden. And it's your burden, is it not, to at least show entire fairness applies. And then Ms. Koster's attorney said, well, they stand on both sides of the transaction. The court said, no, one shareholder does. That seems like you had every opportunity at the district court to, number one, you had noticed the district court was considering these issues. And number two, you had every opportunity to make an argument to the district court. And if you felt like you hadn't had an opportunity to produce evidence that would create a disputed material fact, you had an opportunity to tell the district court no, look, that's not what the summary judgment motion was about. We've been blindsided here. Give us an opportunity, show what we've discovered and put that. It just seems like you're telling us now you didn't have the opportunity to make the argument that I'm reading on page 2894.
Well, we didn't have an opportunity to submit briefing and evidence. This was
Did you
clear,
ask for it at the hearing?
not at the, so
The judge seems to be very, telegraphing. It's going to matter to me whether it's entire fairness or whether it's business judgment. It's going to matter to me whether they stand on both sides of the transaction or whether we should view each transaction individually. And so then only one person is 1/3 on each side. It just seems like the district court is saying, this is the opinion I'm thinking about writing. And at no point does Ms. Coster's attorney say, wait, that's not the issue presented in the summary judgment motion. This is not fair. We didn't get notice. We didn't have an opportunity to put evidence into the record that would create a disputed material fact.
in all fairness, my recollection of that transcript is that we did make that point.
So if that's, and I didn't mean to state with my last point as declarative as I did. So that was my mistake, but I didn't see it on page 2894. So that's why I'm bringing it up now. I'm asking you if you did make that point, where?
I don't have the transcript site. Well, actually, maybe I do. So given the history of this case and how long it had been pending before the district court, it was quite clear to us that asking for additional briefing or turning the oral argument based on the docket entry, it was clear the December 2024 proceeding was going to be oral argument on the pending summary judgment, which had been pending for a long time. It would have been very poorly received by the district court, in our view, if we'd asked to introduce
Probably by
exhibits.
opposing counsel as well.
And I was just going to say that Ms. Baum would have been pounding the table saying this is improper. So we didn't view it as an opportunity, and asking for additional briefing again would have, we had appeared before the district court a number of times. It was quite obvious to us if we asked for that, we would risk alienating the district court.
Fair enough.
Just wanted to follow up on that. District court didn't end up relying on that point anyhow, because it didn't get to the are they on both sides issue, but it struck me as troubling to think of them. I mean, what the district court said as well, in this entity, Schwat's invested, and this one, Bunnell's invested, but they were, I thought your theory of the case was that they were in this together, and it's like, yeah, I'll vote for you on this one, you vote for me on this one. We are jointly invested in these, either jointly invested in the SPEs, or it was just a practice of them always supporting the other ones. If they weren't jointly in a particular SPE, they would always support that.
I think
Their SPE, knowing that they would turn around and support them in their SPE.
so. Virtually all of the SPEs, both Schwat and Bunnell, are jointly invested.
Right.
So that's not, there may be one legacy one, but
Right.
that would be an outlier. They're almost always in one.
Right. So they're definitely on both sides of the transaction if they're then voting for it and then benefiting from it.
Absolutely, Your Honor.
So the district court statement was just inaccurate.
Correct.
I think it was talking about maybe the consulting fees. And I think
That was with respect to the consulting
Oh, the
fee.
consulting fees. Okay, I misunderstood that. But even then, if they're each approving each other's consulting fee, you're in the same situation, are you not?
I agree 100%, Your Honor.
and did you put evidence into the record that it was a quid pro quo? It was log rolling. I'll vote for yours if you vote for mine.
No, we would have had to raise the issue of what standard applied. But they did not contest. In fact, they conceded that the fact that the consulting fees had been made to the tune of millions of
They
dollars.
didn't consult that they were made, which I think cuts against you because yes, it was primed for summary judgment. They weren't arguing about what happened. You were arguing about whether it was legal, whether it was fair. And as for whether it was legal and whether it was fair, the district court is telling you, I think that there was someone, I think that it was, what's the right phrasing here? You were saying they got together and decided to pay themselves consulting fees, sort of in the implication is as a quid pro quo. And the court said, where's the proof of that? I mean, you can't just come in and say that. I'm quoting. And then your attorney said something here, and then the court says, only if it's an entire fairness review. Otherwise, it's your burden. It's your burden. It just seems like, I mean, it's like I'm reading the appellate briefs.
Well, it underscores the centrality of which standard applied. And we cited case law in our briefs. It's often dispositive under Delaware law, which applies. We didn't get to brief that issue. And by the time we got into the hearing and the district court was asking these questions, it was too late. There was no briefing. It was our strong sense. We thought about perhaps asking for post-hearing briefing, but we decided it would just absolutely not be well received. And the case law doesn't require it. Rule 56 doesn't require it. We were blindsided. We didn't think that the district court would rule the way it did. We were surprised when we saw that it was all business judgment rule and that we had not met our burden, because we didn't see ourselves as having any burden under Rule 56C other than to show that genuine issues of material fact existed on the issues, the factual issues they filed their summary judgment motion on. And we did just that. If they had raised the issue of which standard applied, absolutely we would have had a burden and we would have met that burden.
Does the
Thank you, Your
record
Honors.
have evidence that they were in cahoots on the consulting fees? Did you get evidence of that in discovery? I scratch your back, you scratch mine. I'll get my consultant fee, you'll get yours.
Well, there's record. The evidence is that they approved each other's. Now, we get into the exact, motivation, but yes, the record would show if we had an opportunity that they did it consistently. And our theory is that those were UIP profits that should have been distributed equally to the shareholders.
That was your legal theory.
Right.
What I'm asking is, so you say you had evidence at least of a pattern of them approving each other's consulting fees,
Absolutely.
but you never cited or referenced that pattern anywhere in your summary judgment briefing.
We did not, because it was our understanding that it was their burden under the entire fairness rule to show that those were entirely fair transactions. A burden being.
Well, you don't get to the entire fairness doctrine unless you first prove this. I think maybe the district court's question, you got to show that you got to come forward with evidence rebutting the business judgment rule, showing that they were in fact on both sides. That's why I asked. So you had evidence they were on both sides. And if you wanted to get an entire fairness land, you had to come forward with evidence saying, no, judge, they were on both sides.
Well, I think that on both sides was conceded. And I want to go back to the key.
On both sides, as in, I got a consulting fee, or Schwat got a consulting fee, Benell got a consulting fee. They may have conceded that, but that they were approving these distributions for each other.
To be clear,
Even if we don't have to get into mens rea at this point or their intent, I would always consistently do it for you and you would only consistently do it for me. And that's sucking money out of UIP. Why isn't it a problem that you just didn't, you could have said orally to the district court judge, we have that evidence. We have that evidence. We didn't include in our brief because of this seems to be sort of a moving target for us. But to not say we have that evidence, it's deposition XYZ, point the district court to it.
so I want to
At least
emphasize,
file a supplemental letter or something to the district court saying, here's where that evidence is.
if Your Honor looks at their summary judgment memorandum, with respect to the consulting fee payments, which really couldn't be disputed, it couldn't really be disputed there on both sides. They focused on collateral estoppel because they knew there was a problem. And then they had this argument that I think is a big stretch for multiple reasons, that, well, the Delaware litigation collaterally stops Koster from advancing that argument here. That was the focus. That's what we were prepared to discuss going into the December 2024 oral argument on summary judgment, not whether they stood on both sides. And just, again, it underscores the fact that we were effectively.
So is your point that entire fairness doctrine is triggered just by showing or having it conceded factually that there was a pattern of them each getting these consulting fees that the third shareholder was not getting?
We would have to show two things to invoke the entire fairness standard. One, that they were corporate fiduciaries, which really isn't
I'm putting that
disputed.
aside for now, because this question was only about are they on both sides? And if you look in isolation at each consulting fee, there's only one shareholder on the receiving, sort of on both sides, on the receiving end and the voting end. But if you look at the pattern, I think whether they would call it a pattern, but whether there were X number of consulting fees for Schwat, X number of consulting fees for Bunnell. That money's being paid out of UIP.
Yeah, our expert
Zero
report,
consulting fees for Mrs. Coster. Those,
Mr. McDonald's expert report details all of that in a schedule, showing the pattern. The consulting fees happen on the same date. And they're different amounts because Schwat was more senior. But yes, that
so your
evidence,
point is that those facts were not disputed.
correct.
Is there, what I'm asking is there more to trigger to overcome the business judgment rule? Do you have to show intent to,
No, we have to show that, they were fiduciaries.
or they were in, I think you said in cahoots? Do you have to show that in cahoots to overcome the business judgment rule, or is simply a schedule of payments for 2/3 of the shareholders from which the third shareholder is omitted is enough? I just don't know this
So
question to overcome.
the answer is, as long as they're on both sides and they're corporate fiduciaries, the entire fairness standard applies. And it's their burden to say, no, no,
Is it
no.
a transaction by transaction question? Or is it, because you, like I said, you could look at each transaction and go, no, there's only Mr. Schwat on both sides. And that one, no, I'm looking at this one, only Mr. Bunnell is on both sides of this one. Is that how it's applied? Or is it, if you show a pattern,
I think it's
then
both.
is it, well, you got a problem with the one at a time because the district court's right, it's to one at a time. But if you have the pattern and the pattern's the problem, then
Well, the
that may
district,
have been, the fact of dates and times and these amounts wasn't disputed. And so you're putting it on,
so the district court on the consulting fee issue focused on Schwat and Bunnell's capacity as board members. And he said, the district court said, well, there's a third board member, Mr. Cox. And so, if Mr. Bunnell was receiving a consulting fee, then, well, Schwat and Cox approved it. It's completely different when it comes to Schwat and Bunnell's capacity as stockholders, because Cox was not a stockholder. There are only 3 stockholders, Schwat, Bunnell, and Coster. So each time they're giving themselves what we think were profit distributions masquerading as consulting fees, they're teaming up against the interest of my clients. My client had no say in that. There was no,
Your key point is they're teaming up.
yes, there,
Might or might not be true.
yes. And I think that is certainly.
I mean, as a formal matter, it's still, you don't have a majority of shareholders or a majority of the board being conflicted.
And that's the importance of the entire fairness standard. If we show that they're
you
on
don't
both
get
sides.
to the
Okay.
entire fairness standard until you overcome the business judgment rule. And you keep going, well, they were on both sides, and the district court, we're going in circles here, I feel like. The district court said, show me the proof that when Mr. Schwat got X consulting fee, Mr. Bunnell was in on it.
Well, we cited in our summary judgment opposition the schedule prepared by our expert, Mr. McDonald, showing that there was this pattern. It was very consistent. And I think at trial, if ever went there, we would have to show by a preponderance of the evidence, in circumstantial evidence would be enough that they were in fact in cahoots. Now, getting a smoking gun in writing, these guys are too smart to do that. But we could certainly have a jury reasonably infer.
From the pattern.
Correct, Your Honor.
I mean, you could look at, I bet the 3 of us almost always vote the same way in the cases we hear, but it's never me voting with Judge Millett because she voted with me in another case, or me voting with Judge Katsas and voted with me in another case. I think just showing that, yeah, they frequently voted the same doesn't show that they were log rolling.
So I think Delaware law is different on this. When Delaware law looks askance at controlling stockholders, giving themselves what are called non-ratable benefits, monies to some of the stockholders, but not others, which is exactly what you have here. And the Delaware
There are
case.
cases says just a pattern like this.
Sure,
You don't need to show intentional log rolling or scratching each other's back, or I'll do it for you, you do it for me.
Again, because
You
that.
show a intent to exclude the third shareholder, the pattern is enough.
I would, I don't have a specific case saying that because this is kind of an unusual fact pattern. But yes, I think again, we go back to showing by preponderance the evidence that there was this cooperation as evidenced by the pattern and the fact that Coster never got anything in the way of a
I
consultant.
guess, and you'd say she also wasn't getting,
She didn't even know about
she
these.
was, right, well, right, she also wasn't getting, she didn't have viable SP opportunities, she wasn't getting all these, I guess in context of the whole picture you want to present to jury,
Yes.
you would say the jury could then look at this pattern and find that.
That's exactly right, Your Honor.
And that pattern was in your summary judgment opposition.
Certainly, yes,
You cited to the expert.
yes, yes, we did.
I thought you said the table was in there, or that
It's a
was
schedule or table.
in your opposition?
Oh, yeah, it was cited and it was in our statement of material facts. We cite to it. I think it's about the 119 range in our individual statement, enumerated statement of fact.
Mhm.
Now, if they had told Coster about these consulting fee payments and she approved it, obviously there'd be no claim. Or there were some other shareholders that were informed, reasonably informed and approved, maybe it would be okay. But when you have a situation where two stockholders are giving themselves millions of dollars and one stockholder doesn't even know about it and is not getting the same monies, that's not okay under Delaware law.
Did your complaint allege that Vanilla was a controlling stockholder?
No, we did not.
Did you argue that at summary judgment that he was?
We argued it in our summary judgment opposition that Schwat and Bonnell owed fiduciary duties to Coster.
No, I'm asking a smaller question than that. Did you argue in your summary judgment opposition that, now we have the evidence, Bonnell was also by himself a controlling stockholder?
We argued that he had fiduciary duties to Coster as a controlling stockholder. Yes,
So you argued he was a controlling stockholder?
we said that explicitly in the summary judgment
I'm just
opposition.
wondering why you're not saying yes to my question. Yes, we argued he was a controlling stockholder.
You asked whether we asserted that in a complaint.
And then I said, at summary judgment, did you say, now we have the evidence? He's a controlling.
Yeah, my answer was going to be too long-winded, but it's succinctly, it's yes.
Thanks.
All right, thank you, Your Honor.
All right, thank you very much, counsel. The case is submitted.
Case number 25-5200, Arthur Sookra on behalf of his deceased minor child, Taylor Rose Sookra, and April Birch Sookra on behalf of deceased minor child, Taylor Rose Sookra, appellants versus Pfizer, Inc. et al. Mr. Lloyd for the appellants, Ms. Tan for the federal appellees, Mr. Wiener for the Pfizer, Inc. Incorporated.
Good morning.
Good morning, Your. May it please the court, Scott Lloyd on behalf of the plaintiff appellants, Arthur Sookra and April Birch. Very briefly on the facts of bringing this suit on behalf of their deceased daughter. She died of myocarditis that, according to medical professionals, was caused by the COVID-19 vaccine. Our complaint alleges that Pfizer and the government defendants knew of the dangers of myocarditis in people of that age, but they withheld that information, which ultimately led to Taylor's death. Their decision to withhold this information constitutes willful misconduct for which both Pfizer and HHS are liable under the PrEP Act. Sookra's filed suit, and the district court, Judge Shukin, dismissed the Sookra's case, accepting the recommendation of the magistrate. And the Sookra's appealed. There are 4 issues we'd like to address today, depending on the court's inquiries. But first, the question of whether there should have been a 3-judge panel convened in this case to hear the motion to dismiss, and we believe that there should have. The second is whether
let's just dive into that.
Sure, Your Honor.
One that interests me. Why shouldn't we rule against you on that point on the simple ground that you did not timely ask for a 3-judge district court?
Your Honor, we believe that we did. Our request at that point was after the recommendation from the magistrate.
Under the Magistrates Act, you make your arguments to the magistrate judge, and he or she prepares a report and recommendation. And then when you go up to the district court, you have to show why the magistrate judge erred.
Understood.
The magistrate judge did not err in saying that you hadn't invoked this.
Your Honor, the follow-up to that, to our first point is the second point, and that is that the requirement is statutory.
Statutory, but I'm not sure it's jurisdictional. Normally, you have statutory rights can be waived or forfeited.
You're understood, Your Honor. But under our arguments, the PrEP Act is clear that the question is a question of the district court shall impanel a three-judge jury. And
it's mandatory, no doubt.
It's mandatory. And so
It also says such panel shall have jurisdiction over motions to dismiss. Does that sound like jurisdictional language to you?
Yes, Your Honor.
It sounds jurisdictional. I'm not sure it bars a 1-judge district court, forecloses jurisdiction under 1331.
Well, on that, Your Honor, we cite to the case of Shapiro versus McManus, and that's where the Supreme Court dove into the question of when it's appropriate for a single judge to dispose of questions where the statute calls for a 3-judge panel.
Shapiro suggests that had there been a district court can decide a question of subject matter jurisdiction. There's a timely invocation. I'm not sure that excuses you from making a timely invocation.
Well, our original point is that we do think that it was timely for these purposes, and then but returning to
If it's
Shapiro.
Jurisdictional, you can raise it at any time. We have to raise it ourselves. This statute wasn't an issue in McManus.
That's correct.
And this statute says any action under subsection D, which is what you have, shall be assigned initially to a panel of 3 judges. Such panel shall have jurisdiction over the action for purposes of considering motions to dismiss. Did the district court here rule on a motion to dismiss?
It did, Your Honor.
It did.
That's correct.
And the statute says initially. There's no go to the district court, have it figure it out. There are other statutes that let district courts do some initial things like address jurisdiction.
That's correct.
Are you aware of any other statute for 3-judge courts that is written saying it shall be assigned initially to a 3-judge court?
I'm not, Your Honor, and that.
And then saying that 3-judge court is the one that has jurisdiction over, among other things, motions to dismiss.
Right.
That's pretty powerful language.
And we would argue that it's controlling, and that there really isn't any discretion on the behalf of the district court to find outside of that language. And really,
Not even supposed to go to a district court initially. I mean, the magistrate judge wasn't deciding a motion to dismiss. It was making a recommendation, which could have gone straight to the 3-judge court. That didn't.
right, that's our understanding as well, Your Honor. And our appeal Shapiro is really just the closest analogy that we could find to language of this sort, but
You said take Congress's language seriously there.
yes, yeah, and that was our reason for mentioning it in this context, although
This is unique language. I mean, you're dealing with a unique situation here of sort of, emergency approvals of medication in case of public health emergencies and crises, and Congress in that, usual context, emergency context, use language it's never used before.
That's our reading of it, Your Honor. I think in our submissions, we didn't want to go quite that far in case we were missing something, but we were not able to find anything with any statutory language where it's quite as
The
clear as
argument
this.
is take Congress at its word or not.
And that's our argument. Correct, Your.
And so regardless of whether you didn't raise it at the first moment, if it's jurisdictional and the statute uses jurisdictional language, shall have jurisdiction. If nothing else, it has jurisdiction over motions to dismiss. The panel, not a single district court judge, shall have jurisdiction over motions to dismiss.
And that was
We have to address that now.
that's correct. That was our understanding from the beginning, Your Honor. And so moving, if we could, to questions of sovereign immunity and covered persons. The PrEP Act, Section D, it creates an exception to its overall immunity to liability. And those exceptions apply to covered persons. And Section DI2 defines covered persons to include the United States. And we would also say that we would remind the court that this is that the PrEP Act includes its immunity to liability. So the background is a situation where there already is liability existing, and the PrEP Act comes in. It provides essentially a protection against that liability, and
That's also protection against suit.
That's correct. And in the context of this applies for the government in the sense that the government's already liable for torts under the Federal Tort Claim Act, and this is essentially a tort. It's essentially a malfeasance.
Did you file suit
Resulting
under
in-
the Federal Tort Claims Act?
We didn't, Your Honor, but
You
we
didn't exhaust under the Federal Tort, as the Federal Tort Claims Act requires either.
well, that's correct. And our point here is not that the Federal Tort Claim Act is controlling in the sense of what the plaintiffs' appellants had to do at the initial set. What we were saying is that when the PrEP Act arrived on the scene, it arrived in a situation where the government was already liable for torts that it commits. And because acknowledging
It's
that.
only liable for torts it committed under a lot of preconditions, one of which was you have to exhaust. Federal Tort Claims Act exhaustion requirement is jurisdictional, I believe.
Yeah, and well, that's correct, Your Honor, except that what the PrEP Act does is overlays different
Well,
procedural
it has its own exhaustion
requirements.
requirement.
Yeah, that's
You didn't
correct.
satisfy either exhaustion requirement.
Well, to the PrEP Act administrative requirements, we felt that the plaintiff fell in the exceptions to those administrative requirements.
What exception?
Well, the statute itself says that where the liability fund is not funded, then
This one was funded.
correct, Your Honor, it was funded in the sense that it was inadequately funded with respect to Mr. Sookra or the Sookras specifically. And so by the time.
I guess there's two answers to that is if we as a court were to hold that it doesn't apply if you ask for more money than in the fund, everybody is going to ask for more money than the fund has, and no one will exhaust. We think Congress intended this mandatory exhaustion to be skirted that easily just based on pleading.
it's a little bit hard to get into Congress's thinking in creating this requirement that there's funding and.
That's a fair point. But so should courts construe a mandatory exhaustion requirement to be pointless as long as people plead a big enough number in their complaint?
Well,
That's the consequence of your argument.
I think that I would nuance that, Your Honor. I would say that it's more the sense that regardless of Mr. Sookra's or the Sookra's claims in this case, it's not really a question of them specifically and their requests specifically. It's more a sense of what is the general universe of plaintiffs likely to be bringing before this fund. And even taking that and setting the Sookras in particular aside, it's inadequate even really to fund the processing of these claims. And to that point, that's how the Sookras fall into the second exception to this requirement, and that is the Secretary has 240 days to process claims. At the time that the Sookras their claim arose, there was a 10-year backlog owing to there were only 35 people manning the office and again, $15 million worth of resources to handle its claims.
Good, thank you.
All right. Thank you very much, counsel. We'll give you a couple minutes on it.
Thank you.
Good morning, Your Honors, and may it please the court. Caroline Tan for the government. So I thought I would start by addressing the three-judge panel issue. The reference to the shall and the initially, I think, can best be understood in conjunction with 22 U.S.C. 2284, which is the default rule governing Congress's determination that three-judge panels might be appropriate. That particular section, 2284, well, let me start from the three-judge panel provision itself. Towards the end of that provision, it expressly excludes 22 U.S.C. 2284B3, which is the provision allowing three judges panels to conduct the trial in those kinds of circumstances. So by excluding that provision, E5 essentially says that in the context of the PrEP Act, a single judge can conduct a trial, and that's sort of the reason why you have other.
I'm sorry, go ahead.
Well, with the PrEP Act, assuming it's properly invoked, which I was asking your friend about, but you haven't pressed that point. Assuming it's properly invoked, it expressly provides for the three-judge panel to decide motions to dismiss.
So
Includes motion to dismiss on jurisdictional grounds.
So I'm glad you brought up the invocation. I do think it's relevant in as much as it shows you that these plaintiffs didn't necessarily request a three-judge panel or necessarily want.
Let's
Okay,
separate.
setting
Let's
that-
start with the motions to dismiss, because it just seems like it's a very different scheme. 22, you have authority under 2284 that the one judge district court can decide questions of subject matter jurisdiction. But this is a different scheme. It repeals the language that talks about barring entry of judgment on the merits, which might suggest by negative implication, you can enter a judgment on jurisdictional grounds. And you have the express provision that it's a mandatory provision, and it says the court gets to decide, the three-judge court is vested with authority to decide the motion to dismiss.
So I think all of that language is in reference to the exclusion of 22A4B3. So 22A4B3 basically allows basically requires that a 3-judge panel do the trial in that context. And so in the PrEP Act, they remove that requirement, meaning it's okay for a single judge to do the trial. And that's in part why the rest of that particular provision references the pretrial matters. It's just to make particularly clear what the exclusion of 2284B3 is supposed to mean. And I don't think anything about the PrEP Act sort of suggests that Congress wanted to remove the default rule that a single judge can serve a screening function at the threshold.
You think under the PrEP Act, a single judge can try the merits?
I think that's what the exclusion of 28 USC 2284B3
Okay, but the
does.
operative language is the PrEP Act language in E says you have this weird scheme where there seem to be two different assignments to 3-judge panels, but the first one is to decide motions to dismiss and some other stuff. And then there's the second one done by the chief judge of the circuit.
So I think that the district court, like nothing about the PrEP Act removes the ordinary rule that a district court can perform a screening function. So if there is, for example, a challenging 12B6 motion to dismiss, a district court can, under 22A4B1, determine this is something that's appropriate.
Wait a minute, McManus, the Supreme Court told us what this, unless he determines that 3 judges are not required means, and it is a very, very small screening test, as in, does this present such a frivolous claim that it doesn't even amount to a question of federal law? And that, I mean, that's not what courts are not allowed to decide motions to dismiss, even if they're relatively easy or not under even under the 2284 as interpreted in McManus.
I don't think McManus displaced the ordinary rule from Gonzalez that a 3-judge court is not required where the district court itself lacks jurisdiction, or that a single judge can't dismiss for justiciability reasons. And I think it's important.
The justiciability that they talked about there was, okay, there's this exception for claim, which happens, say someone says I'm suing under federal law, but it is beyond frivolous. I'm suing under federal law because I read Title VII to say no discrimination against me because I'm an alien. All right. And so then someone go, that is just, I mean, not even colorable. That doesn't even get past in the front door. That's not sufficient to raise a federal question. We're not in that territory here at all. But that's what McManus gave as an example of what this screening function is. But once you've decided that it claims under the PrEP Act, it's a motion to dismiss under the PrEP Act, you've got to go here. Now that's, I mean, answer that first, but I think there's language here that's
Sure.
not even in McManus world here. We don't even have that screening function.
McManus involved a motion to dismiss for failure to state a claim where the underlying theory brought in that motion was based on a concurring opinion from a Supreme Court justice. And so the idea there was that this claim is somewhat challenging. It's sort of difficult. And for that reason, this claim required a 3-judge panel. That's not what we have here under either the case law regarding a single judge's ability to dismiss at the outset on threshold grounds, or under this court's insubstantiality doctrine. I mean, in this case, there can really be no debate that Congress has not waived its sovereign immunity with respect to PrEP Act claims.
That's a separate problem. One, I don't think one would say there's not enough of a question here to sovereign immunity, even to raise a federal question. Is that the government's position?
That is our position.
So this can be in state court. There's not enough to even get into federal court here?
Oh, our question is you can't sue the government under the PrEP Act.
That's your defense on your motion to dismiss. That's your motion to dismiss. But here, Congress, you're not letting the word initially shall be signed initially to a 3-judge court. I could find no other 3-judge court statute in the U.S. Code that is phrased that way, right? 2284 is kind of like this default rule generally governing these things. But when Congress can override it, correct? Congress can override 2284.
Congress certainly could, but
So
the fact that
signed initially, you don't have to make a request Assigned initially means it doesn't even go to a single district court
So
judge.
we do think you'd have to make a request under 22A4B1.
No, when Congress wants requests, it says it in other 3-judge statutes. So the fact that there's no requirement of request here, how should we interpret that?
I think there is a request under B1, and I think you get there
Wait,
by
under B1.
22A4B1.
No, I want to talk about the statute at issue.
Right,
here.
no.
All
So,
right, so where does it say in there that you have to make a request before it's assigned to a 3-judge court?
so when the PrEP Act excludes B3 and only B3,
Mm-hmm.
Congress therefore says it's okay with B1 and B2.
But not,
And that is-
not if they're irreconcilable. This is my argument to you. There's no requirement of a request. When Congress wants a request, which it does frequently, it says so in in 3-judge court statutes. It says that, uses the word request frequently or application, but that's not here. All right. And then just tell me what assigned initially means to the government.
Our position is that's in reference to the exclusion of B3. When B3 says,
That's way more than B3. B3 is about trials. Assigned initially isn't going to be talking about what happens at a trial.
I think the position is B3 says a 3-judge panel must do the trial. And so, it excludes
I know,
whatever
but you wouldn't
discussion
use
of
the word
pretrial
initially
effects.
to talk about, in fact, this statute already has these cases divided. This is what Judge Katsas was pointing out. It divides these cases into 2 stages. There's the motion to dismiss and summary judgment. And then you got to go back to the chief judge for another 3-judge court if there's going to be a trial.
So
That's why. It's that second half is why B3 doesn't apply. Right? But the first part, assigned initially, who assigns cases? Once a complaint's filed, who does that?
So
I think the clerk's office.
I think when you mention the chief judge and the mechanics of assigning a panel, the PrEP Act doesn't expressly say how that happens. And the way you get there is by looking at 22A4, which is the default rule for how to, 3-judge panels
But
are
it's
to be
overridden.
convened.
You want the district court, you want it to be assigned initially to a district court judge who can then rule on motions to has jurisdiction to rule on motions to dismiss that you think are, they're clearly federal questions are presented here. But they're easy enough in our view. That's how you read the assigned initially to a 3-judge panel, which will have jurisdiction over the motion to dismiss.
We read it consistent with the parts of 2284 that are not excluded. That's our position. And 2284 B1 has not been excluded.
My question to you is why doesn't assigned initially exclude that role for a single district court judge? Because what happens under all the other statutes is it is assigned initially to a district court judge. And then there are times when those district court, depending on the statute, can do various things, right?
So there might be 2 points that might be helpful to your concern. The first is there's a long line of cases that have allowed dismissal for standing and threshold grounds, even though the underlying statute says things like shall, even though the underlying
Does it
statute.
say, if you can point me to one that says a 3-judge panel shall have jurisdiction over a motion to dismiss, which statute says that?
I don't have a statute that uses
there
the
isn't
exact
one.
language.
There isn't one.
Lots of
From what I've
statutes
looked at.
say shall, but nothing
No,
that,
but not shall have jurisdiction over a motion to dismiss.
I don't know of any statute that uses that
Exactly.
precise
Well,
language.
we know
I
of
do.
one. We know of one.
That's, yes, of course, yes.
Okay.
I do think it's, this is a
Shall have-
unique statute.
Right, but that's the point. Shall have jurisdiction over a motion to dismiss unless it's not that hard. That's not what Congress said.
I think the exclusion of B3 suggests 22A.
That's about the trial. B3 is about
Right.
trials.
And so they're excluding the
We're not
part
talking about trials. We're talking about motion to dismiss and summary judgment.
I guess I don't think there can be any real debate that at a minimum, some parts of 2284 B1 are included, including the mechanism by which a 3-judge panel is convened.
Sure, you go to the chief judge.
Right.
And maybe this chief judge is the one that now has to make sure there's a 3-judge is required. This 3-judge court is required. He's got to figure out this is a PrEP Act case or under some other statute. But as soon as that chief judge says this is a PrEP Act case, the case shall be assigned initially to
So
a 3-judge court to rule on any motion to dismiss.
It seems anomalous that 22A4B1 would be incorporated, but not in part, but not the remainder of it, which says upon the filing of request for
That's
three
how we read
judge.
statutes. If you have a later in time statute that uses different language that conflicts, which one controls?
I guess we don't see a
Which one, but if
conflict
there is a
here.
conflict, which one controls?
If there is a conflict, the later one would
Okay.
control, but we don't see a conflict here. We think
Because
these are
initially
compatible.
means to you, assigned initially means to you what?
Because nothing about the PrEP Act removes that default
Textually,
rule.
what does assigned initially mean to the government?
I mean, I suppose
I think you mean not assigned initially, as long as there's a relatively, in your view, a relatively easy jurisdictional question.
I think that there's a whole
Isn't that your
body.
position? And
There's a whole-
based on a whole body of
Yes.
case law that has allowed single district court judges to decide motions to dismiss on jurisdiction.
Yes, that has
Okay.
allowed single judges to dismiss for threshold because no court has the power to hear a claim, for example.
No,
And that's our
exactly,
position with
exactly. But
respect to the
it's-
government.
I'm having a lot of cognitive dissonance saying that it would be consistent with this language that says assigned initially to a three-judge court, and that court is the one that has jurisdiction over, it doesn't say some motions to dismiss, it doesn't say 12B6 motions to dismiss, it says motions, plural, to dismiss.
Again, I mean, looking
If
just at
Congress
terms like
wanted to
shall.
displace those other cases or presumptions, what more did it need to say here? Let's assume, we don't know, but let's assume Congress said, we want to displace that. This is a special situation. PrEP Act deals with health emergencies. We wish to displace it. What language, in your view, would be necessary to be added to this?
I mean, for example, if Congress has said none of the requirements of 22A4 apply, for example, but that's not what they did. They only excluded part of 22A4, didn't say anything about 22A4 B1 and B2. And I think everyone agrees that at minimum, parts of 22A4 apply, including the mechanism by which
What
a
do
judge.
you think the mechanism is? The first assignment, is that done by the district court clerk, the single judge, the chief judge of the district court, or the chief judge of the circuit?
I mean, our view would be
Puzzling.
that I think our view is that what happened here is consistent with the PrEP Act requirements. And so it can go to a single judge. Single judge can always perform some kind of screening functions. Courts have long
But
recognized
if
that.
if there is to be an initial assignment, who makes it?
I suppose it's the clerk's office. I don't quite know, I guess, the mechanics of how cases are assigned behind the scenes, but I don't think there's any suggestion that Congress wanted to make it harder for a single judge to dismiss a PrEP Act suit than it would in other statutes.
I thought your answer would have been the chief judge of the circuit because B1 is preserved, but.
Yes, I mean, that's what has happened in similar cases, that that if someone thinks that a district court thinks a three-judge panel should be convened, you follow those mechanics. I thought your question was maybe going to the initial, like when a case is first docketed in district
No,
court, something like
when
that.
it's first docketed, that's what I'm wondering.
Well, my understanding of B1 is that you notify the chief judge of the circuit if a single judge believes that a three-judge is required.
Okay.
And so I don't know that latter part of B1 would govern in a situation when a single judge doesn't think a three-judge panel is required.
Suppose the initial district court judge thinks a three-judge court is required, then it goes to the chief of the circuit.
Yes, then the B1 would apply, yes. And if it's helpful, the PrEP Act includes a number of very specific pleading requirements in order for complaint to be filed in the first instance. So in 247D-6D and E4, there are, for example, verification requirements. In order for a complaint to be filed, you have to attach affidavits from the non-treating physician, medical records, that sort of thing. And there's no reason to think Congress wanted the convening of a three-judge panel to functionally determine whether certain pieces of paper have been included in the
does not
complaint.
substantially comply.
Yes,
The verification
Yes, but-
requires substantial compliance. Are
That's
there
correct.
case law out there on what they mean by substantially comply here?
I'm not aware of case law. I mean, this is a unique statute as
Yeah.
you stated, but I think the point is just,
So why
There's no
wouldn't
reason-
a dismiss motion to dismiss because they didn't substantially comply go to the three-judge court? Because someone's going to have to interpret what substantially comply means in the first instance. That sounds like a pretty important question
I think
and not an obvious one.
it is functionally some kind of screening function. Have you attached the requisite
How
affidavits
do we
and
know that
medical
attachment
records? I mean,
is what you have to attach to have it to substantially comply, as opposed to in your complaint saying this doctor has attested to this and this doctor has attested to this. How do we know that's not substantial compliance?
I mean,
How do we know? Is that, I mean, a government
I mean,
might
it
have
might-
an argument, the other side might have another. Would it be sanctionable to argue that that's not substantial compliance?
I think the idea is just there are a number of very specific requirements that have to be met. And there's no reason to think Congress wanted all of these pieces to have to go to a three-judge panel. It's
Well, how
it's
would this be
ordinarily,
implemented? Through a motion to dismiss?
I'm sorry.
How would the verification requirement be implemented? Through a motion to dismiss?
If the affidavits haven't been attached, for example, or if the medical
We
records
don't
haven't been
know they have to
attached.
be attached for substantial compliance. That's the difficulty here, right?
I mean, the statutes
I'm just asking you,
for,
how would, if you wanted to say this complaint needs to go away for failure to comply with a verification argument, whatever your reading of substantial compliance is, that would be effectuated through a motion to dismiss?
it's unclear, Your Honor, but it just says shall not be accepted for filing. And so it's unclear if that would have to go through the whole process. I don't
So
fully
it may
know
not go to a
the
judge at all.
mechanics.
Maybe the district court or the court shouldn't accept it for filing.
The language that I see is shall not be accepted for filing.
Right, so that sounds like the clerk, but I don't think the clerk's going to interpret in the first instance what counts as substantially compliant. That's something for courts to do?
I think the fundamental point is there's no reason to think for these sorts of things
Well,
Congress required the
I think there's
convening
a
of a
lot of
three-judge
reason
panel.
if the way you effectuate this is through a motion to dismiss, and Congress said who it wanted deciding motions to dismiss. Why should we think they didn't mean what they said? Your
Again,
argument is
so-
we should think they didn't mean what they said.
No, that's not our argument. I think the reference to motion to dismiss, motion for summary judgment, and all these pretrial matters has to be read in conjunction with the exclusion of 22A4B3. And so it's just emphasizing.
Your argument has to be that motion to dismiss is shorthand for a 12B6 motion.
No, not necessarily, Your Honor. I think the cases in which courts have said a single judge can't do this, the three-judge panel controls tends to come up in the context of 12B6 failure to state a claim where there is a challenging or somewhat hard merits question at issue. But this court this court has recognized that despite statutory language saying that this thing should go to a three-judge panel, it is okay for a single judge to dismiss threshold jurisdictional challenges.
Go ahead, you please.
Jurisdictional.
Or justiciability. Yes, some of them have used the language jurisdictional, but the idea is that the courts don't have the power to hear this case. And our position is that's certainly true with respect to the United States.
You have to read, boy, if you're saying motions to dismiss, this mandatory requirement for the three-judge district court to decide motions to dismiss doesn't even cover 12B6 motions. That seems fair.
No, it certainly covers. It can. I think B1 applies, which says a single judge can determine whether the three judges are required. And so if it's a challenging question, if it's a hard 12B6 or it's up to
You think a district court can dismiss for failure to state a claim on the merits under the PrEP Act?
Ordinarily, it would have to.
Just give me a yes, no, and then I'll.
Yes, under the substantiality doctrine, under whether some case is insubstantial.
Assuming a substantial merits question.
Then the answer is no.
Okay. But you think a district court can decide contested questions of subject matter jurisdiction because that was the practice under 2284.
We think the substantiality doctrine sort of recognizes that for certain straightforward, sometimes frivolous cases.
Contested.
Well, contested as in the other sense.
Motion to dismiss on jurisdictional grounds, and it's a hard motion. There's good arguments on both sides.
In that circumstance, I would say, I think B1 lets the district court decide, but they should probably send it to a three-judge panel. Well, I don't want to.
What is your substantiality test? There is the completely frivolous, not enough to even trigger federal court jurisdiction. Let's say we're out of that world. When is it substantial and it's disputed? And when is it substantial enough? So put aside the frivolousness stuff, which McManus talked about in particular. What north of that? What's the line for when it goes to 3-judge court or stays with the district court?
I don't think there's an obvious test here, Your Honor. I think the cases have looked at every single statutory provision and the nature of the claim at issue. I think in this case, when it comes to whether Congress has waived sovereign immunity for these claims against the government, that's on the obvious side because you don't usually get statutory language as clear as what you have here about waivers of sovereign immunity. I mean, F says nothing in this section shall be construed to waive sovereign immunity. It's really hard to imagine Congress being clearer about the extent to which you can sue the United States. And the language here.
You haven't argued that their argument is sanctionable.
I'm not sure that any court has said sanctionability is the test.
No, but you've got, so it's not frivolous in that regard. And they point to some different language that's like, well, why are we bothering to make them a covered person if they're then going to be immune from all the things that covered persons are subject to? You have your answers.
Yes.
We're not here to that right now. That's
I appreciate that.
eventually, but we have to decide who's going to make that decision in the first place. But why wouldn't Congress, when it assigned motions, plural, to dismiss to the 3-judge court, have expected anything that's north of what McManus talked about on, if it presents a question for a federal court to decide, it's enough of a question for a federal court to decide. Why isn't that the category of cases that goes to the 3-judge court, which shall have jurisdiction over such motions?
I think it's because under principles of sovereign immunity, no court has the power to hear this case against us. That's our primary
Do we have
position.
power to rule?
Not on, of course, on jurisdiction, I'm not.
Well, but that's what we're deciding. That's what we're deciding is who decides. You agreed that your argument as a district court judge had the authority to decide your sovereign immunity argument, correct?
A district court
A
can.
single district court judge. That's your argument to us.
Yes, can dismiss this case against us under
A
principles.
3-judge court could not?
No, that's not our position. No.
Okay, so that,
No.
I don't see where that argument gets you.
This is sort of the way in which courts that have allowed dismissal on standing grounds have discussed
Under
that.
statutes that aren't written this way.
I agree that the
Other
statutes,
statutes say shall. Do they say shall have jurisdiction over motions to dismiss?
like I said, I'm not aware of any other statute that uses that exact language. But the idea is notwithstanding the word shall, or, similar arguments about the mandatory nature of the language, courts have nevertheless
It's
recognized that.
jurisdictional language here.
So
I'm not, that's not even required under Supreme Court precedent to make it jurisdictional, but at least it hasn't always been. But here, you have this language that is really targeted to this very emotion you want. And I just can't understand what the line is. Once we agree there's enough of a legal issue that you open the courthouse doors for somebody to decide this motion to dismiss, either a single district court judge or a 3-judge district court. So we're now in that category. And I think you say that's what category this case falls into.
we don't challenge federal question jurisdiction, no.
Right. So
We just don't.
we're in that category. All right. And that category Congress has already told us in the statute who has jurisdiction over that motion to dismiss. And do you want to say, pay no heed to that statutory language because there's a long practice under other statutes differently written that allow district court judges?
So are two responses. I mean, I think the fact that Congress only excludes B3 is meaningful. And it means that B1 and B2 come in. And B1 says that you have to file a request for a three-judge panel, and that a single judge can determine whether three judges are required. And that body of case law has permitted single judges to dismiss at the threshold, including, and this court has recognized that as well. And so our position is that
There's
that
already been
applies
an
here with
instance in
respect to
this
sovereign immunity.
courthouse, the Watts versus Hegseth case, where Judge Nichols said at the 60B stage, you're right, you're entitled to a three-judge court. Our chief judge appointed a three-judge court, and the three-judge court took jurisdiction over that motion to dismiss. There's already a practice in this courthouse.
So I think that's consistent with our reading of the statute, Your Honor, because B1 says a single judge can determine whether they think three judges are required. And so Judge Nichols in that circumstance determined that he agreed, he believed in that circumstances, three judges were required, but it's
that a motion to
equally.
dismiss had to be decided. The motion, all the way back to the motion to dismiss, had to be decided by a three-judge court.
Again, I think the reference to the motion to dismiss and all these pretrial motions is just read in conjunction with the exclusion of B3. I don't think it says anything different about displacing the ordinary rule under
He vacated his decision
2284.
on the motion to dismiss, which
Yeah.
I believe included sovereign immunity.
Yeah, I assume so. I'm not that
Yeah.
familiar with.
So the very issue here is
I-
we've been to this rodeo before in this courthouse, this court.
I mean, I guess two responses. I mean, the first is our position is not that a judge has to dismiss if they agree with our position on sovereign immunity. It's that a single judge can decide that three judges are not required. They can make that decision, and you get that from 2284B1's language.
Okay, so you're reading it to,
It says,
shall be assigned initially to a district court judge, which will decide in its discretion whether or not the motion to dismiss is tough enough that it should be assigned to a three-judge court.
we're reading that from, E5
That's how
excludes
we're reading this
B3.
language. You're saying 2284 actually tells us to read this language the way I told you.
We're reading
What
E5
about
in
how I
conjunction with 22.
suggested you were reading it? Tell me if I'm wrong, is incorrect.
We
They'll be
read,
assigned initially to insert a district court judge, which will, in its discretion, based on how difficult the motion, jurisdictional motion, or maybe any motion to dismiss is, to decide it itself or give it to
so
a three-judge court.
sort of the difficulty language comes from the insubstantiality doctrine and Shapiro and McManus. I mean, the way that the courts analyze this is they look at the underlying claim and they evaluate whether, if it is challenging, then this is the sort of thing that a three-judge court should do. None of those cases displace the ordinary rule that, again, a single judge can serve a screening function. And when it comes to reading E5 itself, we read it in conjunction with 2284, and we think you get there because E5 only excludes 2284B3, just says nothing about 2284B1 or B2, and sort of it therefore follows that the ordinary requirements under B1 and B2 would apply here.
No, McManus, I can quote you at 44. Section 2284B1 merely clarifies that a district court judge need not unthinkingly initiate the procedures to convene a three-judge court without first examining the allegations in the complaint. In short, all the district court judge must determine is whether the request for three judges is made in a case covered by 2284A. No more, no less. So all you have to do here is determine whether this is request for three judges made in a case governed by the PrEP Act.
And the district court can determine that the cause of action plaintiffs invoke here cannot be applied to the United States because that cause of action is subjected to subsection F, which says nothing in this section shall be construed to waive sovereign immunity. And our position is that that was completely appropriate for the district court to handle without convening a three-judge panel. It's hard to get clear language about what Congress meant when it came to waiving sovereign immunity than what we have in subsection F.
Thank you very much, Counsel.
Thank you.
Your Honor, and may it please the court, David Weiner for the defendant Appali Pfizer Inc. Your Honor, I'll just pick up where Ms. Tan left off. And on the issue of what the single district court has authority to do in circumstances where there's a statute that requires appointment of a 3-judge panel. And I think our understanding is that there are several routes that the court can take that can permit dismissal. One is by way of B1, 2284 B1, and that it's that initial determination. And this is similar to what happened, one of the cases we cited, Community Oncology Alliance, one of Judge Kavanaugh's decisions. And there, the single judge can make a threshold determination about whether or not the statute under which the plaintiff is suing actually requires appointment of a 3-judge panel. So that's one approach. The second approach, I think, and that of course also is the reading consistent with Shapiro versus McManus. The second is the insubstantiality doctrine. These are circumstances where the merits of the claim are so weak, frivolous essentially, commanded by Supreme Court binding precedent that the claim is a failure. In those circumstances, a single judge can determine this claim is so weak, you haven't even opened the door for federal question jurisdiction. I can dismiss it on my own without sending it to a 3-judge panel. The last category.
Neither of those are this case.
Well, let me caveat that for a second and just say that I think that there is potentially a hook with respect to the medical record requirement because the language in that provision is so unique in saying that a complaint that does not substantially comply shall not even be accepted for filing.
Who decides whether it's substantially complied? The clerk?
Well, I think the use of that language suggests that that is a jurisdictional requirement. And that brings me to the third category.
Who decides that jurisdictional question?
I think in the absence of a clerk making that decision, which is not going to happen, clerks aren't going to do that.
Do you think Congress wanted clerks to decide substantial compliance?
I honestly don't know.
You think it took away the power of courts to define what law means, what a statute means?
I think what Congress was doing is saying that this requirement is so important, it is jurisdictional. And if it is jurisdictional, I think the single judge under Gonzalez has the authority to grant a motion to dismiss because it is not justiciable. And I think that is entirely consistent with use of shall initially.
Does a court, it may say, assume your reading is right. It is unusual language. All right, assume your reading is right. Would you agree to clerk or the court isn't expected to do that? Congress, it would have been quite troublesome if it had said, let's keep this away from the judges. Let's let the clerk of the court define what this substantial compliance test means. So who's supposed to decide in the first instance? A court.
The court will make that determination.
The court will make a determination, and it will do so through a vehicle known as a motion to dismiss.
And correct, Your Honor. And so on that issue.
We're not there yet.
I'm sorry?
We're not there in this case.
So Congress did not say in the PrEP Act that a single judge could never determine whether or not a claim that happens to end up on its docket under the PrEP Act is justiciable or not. Congress could have written the statute that way. Congress empowered 3-judge panels under the PrEP Act to decide motions to dismiss and to decide summary judgment. We don't dispute that. We do not dispute, of course, that this could have been referred to a 3-judge panel, and a 3-judge panel could have granted the motion to dismiss.
Could be assigned initially instead of shall be assigned initially. And when it says who has jurisdiction, such panel or a district court judge shall have jurisdiction. That's how you want us to read this language.
I think.
Am I wrong? Are you not asking us to say that shall be assigned initially should mean shall be assigned initially to a district court judge or a panel of 3 judges in the judgment of the single district court judge?
No, Your Honor, that's not our position. Is that
it can't be assigned initially to a district court judge
in circumstances where a clerk just as a clerk is not making a threshold determination about whether the medical verification requirements have been satisfied, the clerk's office is not looking at every complaint to determine whether or not it requires a 3-judge panel. My recollection,
Then we're in McManus world where they say what the district court judge it just goes to a district court judge whose job then is to look at that and go, whoa, PrEP Act. And the
And
chief judge now.
I agree, that is one route under Shapiro versus McManus, but I don't think anything in the PrEP Act displaces the authority that a single judge has under Gonzalez to also determine whether or not a complaint that is presented to it is justiciable or not before making a
What do you
determination.
mean by justiciable?
I'm sorry.
What do you mean by justiciable?
In Gonzalez, there was a lack of standing. And I think the court, all of the cases that
Motion to dismiss for lack of jurisdiction.
it is 12B1, that is correct. And I don't think that there's anything in the PrEP Act when Congress empowered 3-judge panels to rule on motions to dismiss and motions for
It
summary
didn't empower
judgment.
them, it assigned them jurisdiction.
It did assign them jurisdiction, but Congress did not expressly take away the authority of a single judge to rule on a 12B1, which Gonzalez and the Supreme Court was very clear. Shapiro agreed with that.
All of the 2284 cases I found allowing the single judge district court to do something pre-assignment involved subject matter jurisdiction. So in order to, do you think that, I mean, don't you have to show that this exhaustion requirement is jurisdictional in order to, assuming the background practice carries over to PrEP Act, you still need to show that this exhaustion requirement is jurisdictional.
Right.
Do you agree with that?
So I think Gonzalez refers to justiciability or jurisdiction, but I think I agree with you that as a substantive matter, the cases themselves involved subject matter jurisdiction. In terms of the second part of your question, I think we have sort of two
Yeah,
arguments.
you know where I'm going with
I
this.
do know where you're going.
You're citing cases from 25 years ago and there's been a sea change in
Yeah,
what counts as jurisdictional and what counts as claims processing.
right.
And
I understand that. And
this language, if you
so I had two
apply modern
responses.
case law, it sure reads like a non-jurisdictional.
Right. And so we have two answers to that. Number one is that I do think that the medical verification requirement uses language that is very different. And that language, that's 247D-6D E4A.
Is that
And-
motion or your motion to dismiss?
I'm sorry?
Was that raised as?
That was included in our
12B1 or 12B6?
I don't remember, Your
Because in a
Honor.
brief, you just kind of throw it in at the end like it's 12B6.
I honestly,
We
I
don't really need to decide that now.
don't remember if it was a B6 or B1. I know our motion to dismiss included both B1 and B6, and I honestly don't remember if the medical
Say the way it's
verification.
At the end of your brief after exhaustion and everything.
Well, it has never been disputed by the plaintiffs that they didn't satisfy or comply with the medical verification requirement.
Have they
they-
conceded that what they did by naming in their complaint, the 2 doctors
They
who
have,
would say this, that have they said that doesn't even count as substantial compliance? We agree with that?
they have not said we agree with the defendants, but we argued in every filing that they did not substantially
Attached
comply.
affidavits is what you guys argued.
No, that's actually not. We also argued that what they didn't satisfy is 247D-6D E C Romanet 2. And that is the requirement to attach the certified medical records from the treating physicians that show evidence of proximate cause. That's what they don't have. And if you look in the JA, I think it's at page
Sorry, I'm trying to find
70,
in your brief here.
what their
Where
records,
is it in your brief here?
um,
Sorry, I'm just having trouble finding it real quickly. You have it on 16.
oops. I think it was at 16.
That's it.
And what their
What you
records,
have is because the complaint on 17 never satisfied the threshold gatekeeping requirements. I think you're talking there about both exhaustion and the attachments, but if you're only talking about the affidavit requirement.
so it's
It did
not this,
present a willful misconduct claim
So
It would have required a full to three-judge court. And not presenting, that sounds, is that failure to state a claim?
I don't, as I said, Your Honor, I don't know whether we did it as a 12B1 or
I'm talking about what you're
12B6.
doing here in this brief.
In this brief, I mean, I think what the argument that we're making here is that,
Paragraph.
that
I don't think you're talking about substantial compliance in here. That mentioned.
that's because there was no compliance whatsoever. It's not disputed. I mean,
I think, what do you mean is not disputed?
well, we raised it in the
It says
motion.
substantially comply, and their complaint has both of them named it. Maybe the answer is that's not substantial compliance, but I don't have any basis for knowing that without briefing and argument on that issue,
And
let alone whether it's jurisdictional.
And I think, again, our position is it was not disputed in front of the magistrate, in the objections, and it's not been disputed in this court that the medical
Okay, I'll ask my
records.
rebuttal if they believe they substantially comply.
Sorry?
If he concedes they haven't substantially complied, then that will be a different.
And Congress,
Well, it's
just
still a
as,
question whether we can decide it.
well, and that was the initial point, is that Congress used very specific language in the medical verification requirements, saying that a complaint that doesn't substantially comply shall not be accepted for filing. Our view is that this has jurisdictional overtones by the use of that unique language. They do not have records. The records that they submitted, they don't even mention the COVID-19 vaccine, which is the covered countermeasure. That is the entire basis for the willful misconduct claim. So in these circumstances, we think that the district court properly dismissed on that basis. In terms of the other part of your question, Your Honor, I understand the case law has changed somewhat. I do think that the PrEP Act is a unique statute and differs in very significant ways from some of the cases that you might be thinking about, like Arbaugh, Reed Elsevier. Arbaugh, for example, it didn't even, I think, mention exhaustion. It was the 15-employee requirement for a Title VII claim. PrEP Act obviously works
One
very.
through line in those cases is whether the requirement is directed at the court or the party. This is squarely directed at the party.
I think the one distinction I would draw, I mean, I think, for example, in Reed Elsevier, the registration and pre-registration requirement for the Copyright Act is doing something very differently than what the administrative exhaustion requirement is doing in the PrEP Act. In the copyright circumstance, what Congress was doing is essentially requiring the copyright holder to sort of give notice to the world, I have this copyright, and we can't have an infringement claim unless the world knows about that. That, I think, looks very different from what Congress was doing in the PrEP Act, where they essentially they preempt tort liability, and then they created this no-fault administrative compensation scheme because they were trying to do something unique. We're barely years out of an extraordinary public health emergency where the PrEP Act functioned extraordinarily well. Congress wanted to incentivize companies, manufacturers, distributors to create covered countermeasures to combat these public health emergencies. That's what happened with the COVID-19 to extraordinary success. And in order to make that happen, Congress wanted to take away liability, provide protection, but create this no-fault administrative compensation scheme through the countermeasures injury compensation program. And only after you have done that, and only after you have exhausted your administrative remedies and seen if you have the ability to recover, only then can you go into federal court. And so I think that.
Wouldn't it also be part of that protection to say, and even when you go to federal court, we're not going to have a single district court judge deciding whether you get sued and your case goes forward, whether there's jurisdiction and whether they've stated a claim. They're going to have, if any plaintiff to get, past the threshold motions to dismiss is going to have to convince at least two of a three-judge court. Isn't that more protective?
So I would agree with you in part, Your Honor, but I think you blended together motions on the merits and motions on jurisdictional issues. And so I think absolutely, if you're talking about a decision on the merits of a claim,
12B6?
I think a 12B6 probably has to go to a three-judge panel. Subject, I guess, the insubstantiality doctrine, I guess, would be a 12B1 argument. But I think when you're talking about, as Gonzalez said, issues of justiciability and subject matter jurisdiction, which are 12b1, I don't think that the PrEP Act prohibits a single judge from making those sorts of determinations, just
They make
as,
them for you or against you?
I'm sorry?
Congress doesn't wanted to, it's very serious protection here. It's rare for them to say, we're going to create a fund. That's how this is going to be dealt with. Yes, after you've gone through that, then there's this other process to go to court, but it's on this narrow claim. And up front, we want this in the hands of 3 judges, not 1. Sure, you like it when the 1 judge rules your way, but there'll be loud complaints when 1 district court somewhere in the country rules the other way. We're going to bypass that process. Is there a way to read the requirement that a 3-judge court also decide motions to dismiss for lack of jurisdiction as of a theme with Congress's layers of protection here for situations of, health emergencies in the country?
I think the answer to that is yes. I don't think that Congress took away the ability of a single judge to determine their own jurisdiction, just as they're able to do in all of these other cases.
No, Congress didn't have that desire to give that layer of protection.
I think with respect to decisions on the merits, it did. And I don't
So when
think,
it says motions to dismiss plural, what other than 12b6? Motions on the pleadings? What else? Pretty rare and unusual.
well,
motions on
I
the
don't,
pleadings.
I don't think that when Congress said motions to dismiss, it was displacing the ability of a single judge to rule on a 12b1. It absolutely was saying that a 3-judge court could grant any type of motion to dismiss, 12b1, 12b6. We absolutely do not
We're going to
dispute.
vest jurisdiction first in the district court judge to make that decision.
Well, I think in circumstances like you have here, where a PrEP Act case ends up on the docket of a single judge, just as I think Judge Chutkan could have made a determination. Suppose, for example, that the complaint, instead of being about a COVID-19 vaccine, was about something that did not qualify as a covered countermeasure at all. Or suppose that no PrEP Act declaration had been issued. And in those circumstances, I think a single judge could have made the determination, which is consistent with 2284b1 and Shapiro versus McManus and Community Oncology Alliance, that the case doesn't even implicate the requirement, the statutory requirement to have a 3-judge panel.
Well,
I think a single,
oncology, did the statute not say 3-judge courts, quote, in accordance with section 2284?
it did. And I think, again, here, as my colleague from the Department of Justice explained, and I agree with, 2284b1, I don't think that there's anything in the PrEP Act that displaces its application from this statute. They carved out B3, as we all agree, and 2284A says essentially, in circumstances where a 3-judge panel is required, here's what you do. B1 sets forth the procedures and composition of the court. I think B1 is in play here for PrEP Act cases.
Great. Do you have any questions? Thank you very much.
Thanks, Your Honor.
Lori will give you 3 minutes for rebuttal. Do you believe your complaint substantially complied with the statutory requirement?
Yes, Your Honor. But the plaintiff actually did submit the that required affidavits, and we do believe that it complies. And we also believe that to the extent that a court would find that it does or doesn't, that would be a 3-judge court as required in the PrEP Act. A couple things that we wanted to mention regarding Shapiro. Shapiro is, Gonzalez has come up a couple times. I think Shapiro addresses Gonzalez and clarifies it a little bit. In Shapiro, it's giving us the only example it gives us as something that a single judge can handle on his or her own. That's an example of just diversity jurisdiction, and that's a simple question of whether the case is spanning 2 states. But it goes on to say that where the case requires any statutory interpretation, anything substantive, then that's where a 3-judge panel has to get involved. And we think that applies here, and that's controlling. We also do want to mention that the statute, it does not impose a duty on the plaintiff initially to request a 3-judge panel. It's by operation of the statute, and it's something that the plaintiff from the beginning viewed as automatically and part of the statutory scheme. And I think that's it. Except to bring up the last point that I think both defendants are bringing us to 2284, but we think that the PrEP Act, it really established a separate statutory scheme, and 2284 doesn't really get us where we need to be. Thank you.
Thank you very much. The case is submitted and we will take a brief recess.
Stand, please. This honorable court will now enter into a brief recess because the final case to be argued involves sealed materials. Oral argument will take place in a closed courtroom. Everyone in the gallery except law clerks, arguing counsel, and other individuals approved to be present is asked to promptly exit the courtroom at this time. Let me see. I think that's one of the other outlets. I think that one.
Yeah, it is. And it's actually both of these cords. So it makes me think it's not. So here's a white one. The black one goes from here to here. Right.
Oh, then that's definitely. I think it was just soft.
Was it just?
Let's see if that works.
Thank you so much.
You guys like everybody here who speaks to the public. We'll just sort of lock everything. Okay. Long haul, right? Everybody's going to see.